Welcome back to Understanding Tribal Treaties and Reserve Rights. In our first episode, The Unique Status of Tribal Nations, we explored tribal sovereignty. In Treaties, the supreme law of the land, we looked at tribal treaties. In our last episode, Beyond the Paper, The Power of Reserved Rights, we unraveled the concept of reserved rights. In today's episode, Treaties and Reserved Rights in Action Today, we'll discuss how treaties are interpreted and implemented in the modern context. We'll show a couple examples of how treaties continue to be powerful tools in protecting tribal rights to use and access natural and cultural resources. We'll then talk about the tools that courts use to interpret treaty provisions and apply them in today's world. By the conclusion of this episode, participants will be able to provide examples of the contemporary impact of tribal treaties, sovereignty, and reserved rights in various fields, such as law and environmental protection and economic development. As a reminder, we are grateful to the tribal leaders who have joined us to share their own and their tribe's experiences and views. And note that these tribal leaders are speaking as representatives of their sovereign nations and not providing the views or opinions of the federal government.
In this course, we've spent a lot of time discussing the historical status of Indian tribes and the history of federal-tribal relations. This is because history matters. The historical context is the necessary backdrop for understanding how treaties and reserved rights work today in the lives of contemporary tribal nations and tribal members. The federal government ended treaty making in 1871, but treaties continue to be a vital part of life for many tribal nations and are of deep importance to cultures, economies, governments, and subsistence to tribes today. We're going to talk now about two modern-day examples of tribes asserting their treaty rights to protect use of and access to natural and cultural resources. The first example involves tribal fishing rights under the Stevens Treaties, which are a series of treaties signed in the mid-1850s between Governor Isaac Stevens and Native American tribes in the Washington Territory. These treaties were approved by the Senate and signed by President James Buchanan in 1859. A common provision in these Stevens Treaties was the express reservation of tribal fishing rights. Under this provision, tribes reserved the right to fish at all usual and accustomed fishing sites off the reservation, in common with non-Indians. The exclusive right of taking fish in all the streams were running through or bordering said reservation is further secured to said confederated tribes and bands of Indians, as also the right of taking fish at all usual and accustomed places in common with citizens of the territory. Before we get to how the Supreme Court interpreted this language, let's talk about what's obvious from the text of this provision. The treaty recognizes that the tribes have an exclusive right to take fish from water inside and bordering the reservation. Outside the reservation, the tribes have a right to fish in their usual and accustomed fishing places. The phrase, in common with citizens of the territory, clearly means that the tribe's treaty fishing rights off reservation are not exclusive rights, but rights shared with non-Indians. But what's not as obvious is the question of how much fish. How do we quantify this treaty fishing right? How much fish are tribes entitled to take under this treaty provision?
According to the Supreme Court, the answer is a fair share of the available harvest in the Puget Sound and nearby waters. A fair share does not mean an equal opportunity to catch fish on the same grounds as non-Indians. Rather, it means a fixed share of the available fish, up to 50% of the available harvest, as necessary to provide a moderate living to the tribes. Let's consider another scenario. A tribe has a treaty right to fish, but the state has built structures that have harmed fish habitats and significantly diminished the fish available for tribes to harvest. Can the treaty right to fish include a right of habitat protection? Can the treaty require states to refrain from taking actions that degrade fish habitat? These are facts from a case known as the Culverts case. The state of Washington had built culverts under its roads, which blocked hundreds of thousands of salmon from reaching their spawning grounds and other important habitats. This caused a significant decline in salmon runs, and in turn, the amount of salmon available to treaty tribes. The question was whether the state had a duty under the treaty to preserve fish runs and habitats. The Ninth Circuit said yes, and that the state had an obligation to replace or remove culverts because they threatened the survival of the fish that the tribes relied on. Here, in this case, the treaty fishing right protected not just the fish themselves, but also their habitats. These are just a few examples of how treaties continue to be powerful tools in protecting natural and cultural resources. It is important to bear in mind, however, that each example is unique and that even when dealing with similar treaty language and rights, treaty interpretation differs according to the historical circumstances of each tribe and treaty. Each treaty must be reviewed individually in its proper historical context. This is why claims to treaty and reserved rights are among the most complex and frequently litigated areas of Indian law. However, when trying to determine the nature and scope of treaty rights, there are certain rules that courts apply to all treaties. First, there are the rules for determining whether a treaty right exists. Treaties and treaty rights remain valid unless and until Congress clearly expresses its intent to limit or extinguish them. Remember, Congress and only Congress can unilaterally limit or extinguish tribal treaty rights. However, there must be clear and explicit evidence that Congress intended to end the treaty or the treaty right. Such intent cannot be implied. It must be clear, plain, and unambiguous. This is a very high bar, and it protects treaty rights by ensuring that treaties are not limited or extinguished in a backhanded way.
There are also rules for interpreting treaties, which are commonly referred to as the canons of construction. We'll talk about two of those canons today. The first canon requires courts to interpret treaties as the tribes themselves would have understood the agreements at the time of signing. This rule recognizes language barriers faced by tribes in treaty negotiations. For example, many tribal members would not have spoken fluent English at the time nor been familiar with the legal meaning of certain English words. This rule also recognizes the unequal bargaining position of the tribes at the time of the treaties. The second canon mandates that courts should generally resolve any ambiguities in treaty provisions in favor of the Indians. In practice, what this means is that if there's any language in the treaty that is unclear or subject to more than one possible meaning, courts will resolve the conflict in favor of the tribal interests. This canon recognizes and accounts for the special relationship between tribes and the United States. As the Supreme Court has explained, it is our responsibility to see that the terms of a treaty are carried out, so far as possible, in a spirit which generally recognizes the full obligation of this nation to protect the interests of Indian people. In addition to looking at the words of the treaty, the tribe's understanding of the treaty at the time it was negotiated, the surrounding historical context, and subsequent congressional action, it is also necessary to research any case law. Working with your agency's attorneys and experts such as linguists and historians when appropriate is essential. More than a century ago, the Supreme Court developed these interpretive rules in recognition of the special federal-tribal relationship and the bargaining inequities between tribes and the United States. In negotiating treaties, the parties were not dealing at arm's length with equal bargaining positions. The United States came to the bargaining table in a superior negotiating position and with superior knowledge of the language in which treaties were recorded. It is important to recognize and account for this history when trying to interpret the meaning of treaty provisions and apply them in today's world.
Your takeaway for this episode is that you should approach questions of treaty and reserved rights on a case-by-case basis with your attorneys. You should also reach out to relevant tribes for their views on the treaty provisions at issue.
I wish federal employees, before meeting with the tribes, understood the treaties of the tribe and the difference in the treaties between tribes, especially if there's, opposition or concerns from other tribes, and you need to really understand the full history of those treaties and what those treaty rights were.
Now that you have completed this episode, you should be able to provide examples of the contemporary impact of tribal treaties, sovereignty, and reserved rights in various fields. Join us next time as we conclude our exploration of tribal treaties and reserved rights. Until then, remember, these are complex topics and the landscape is often shifting, But if you start with respect for tribal nations, then you are starting your journey on the right foot.